Ladies and gentlemen, welcome. I am Jeffrey Rosen, the president of the National Constitution Center, and it is a thrill to welcome you to a historic conversation between the Constitution Center's first honorary congressional scholars, Chris Coons and Mike Lee. This room has been the host of many historic events. I've learned that from the Teapot Dome to the Watergate scandal, there have been great discussions here, but I think we are going to top all of those remarkable
Jeff, does that mean we are the latest scandal to be investigated?
No. On the contrary, we're going to redeem the spirit of this room in the spirit with which John F. Kennedy announced his presidential campaign, and I'm sure there were some great Republican events as well. Ladies and gentlemen, this is a big deal, because the National Constitution Center was founded by Congress during the bicentennial of the Constitution to disseminate information about the U.S. Constitution on a nonpartisan basis. And in these polarized times, it is so important that these two distinguished senators who care so much about the Constitution have decided to be our honorary congressional scholars to teach Americans across the country about the importance of constitutional as opposed to political debate. So the only ground rules for our conversation here and throughout their visiting scholarship is that we are not going to talk about politics. We are only going to talk about the Constitution. They will agree about some issues, they will disagree about others, but you are about to see two really fine constitutional minds at work. And this is going to spread across the country. We're going to have scholars from the House, and we think that this will elevate constitutional discourse in America. Let me briefly introduce them, and you'll realize why we couldn't have two better scholars to inaugurate this really thrilling program. Chris Coons, the junior senator from Delaware, elected in 2010, serves on the Senate Judiciary Committee's subcommittee for the Constitution. I knew him from back in law school when he was one of the most ardent and informed constitutionalists in our class. It is just a thrill to see him bringing his acute intelligence to the floor of the Senate. And Mike Lee was elected in 2010 as the junior senator from Utah. He is on the Judiciary Committee subcommittee on privacy technology and the law. He had developed a passion for the Constitution when he was young, when his father, the very distinguished U.S. Solicitor General, I think you watched him argue before the Supreme Court. He's devoted his career to defending the Constitution. He came to the Constitution Center and loved it so much. I think you called it Constitutional Disneyland. You were here with your wonderful wife and family who cared just as much about the Constitution. And at that moment, I knew that he was the perfect visiting scholar as well. Ladies and gentlemen, please join me in welcoming Chris Coons and Mike Lee. We have 45 minutes, and we're going to jump right in. The topic to begin with is the separation of powers. The Constitution, which you can all pick up outside the room, specifies that in Article 1, that the legislative power is vested in Congress, Article 2, the executive power in the presidency, and Article 3, the judicial power in the judiciary. Mike, what does the separation of powers mean to you?
It means that within the federal government, we don't want any one person, we don't want any one group of people to accumulate too much power. The Founding Fathers understood at the time they wrote this document that these were three distinct functions: the act of making the law, the act of enforcing the law, and the act of interpreting the law, where two or more parties disagree as to its meaning. And that it made a lot of sense to have those in three coordinate branches of government. And so, to the extent that we followed it, it has worked well for us. It has protected us against the kind of tyranny that we have been warned about for centuries, one could say for millennia. But this was a warning that the Founding Fathers heeded, and I think wisely so, one that had been put forward to them by Charles de Montesquieu, among others, who explained that whenever you fuse the power to make law with the power to enforce it, you're on the high road to tyranny. Bad things are going to happen, because the same person or the same body of magistracy will make a tyrannical law, will also enforce that law tyrannically if given the opportunity to be both lawmaker and law enforcer.
Wonderful. And note how in the bipartisan spirit, they're actually sharing the microphone and passing it back and forth, which is great. Chris, what does the separation of powers mean to you, and how does it affect your daily work as a senator?
Well, let me first agree with Senator Lee that the foundational principle that appealed to the authors of the Constitution drawn from Montesquieu, was one that said the tyranny they had experienced under the British monarchy, the tyranny that they saw around the world at the time in absolute monarchies, was where the concentration of these three different types of power in one individual or in one government really crushed the opportunity for individuals to exercise their liberty. And so our founders, both in how they conceived of and then drafted the Constitution, and as further discussed in the Federalist Papers, imagined that having three coordinate, distinct branches with a division of power between them was essential to the protection of liberty. And I'll say that it is something that is a constant theme in our current work. There are, in some instances, suggestions that the current balance of power is out of whack, that the executive branch is overweening and overly strong. There are areas where I think we can and should, on a bipartisan basis, have Congress assert itself more. But I also think in our work today, it's important to take into account the dramatic change in context from the time when the Constitution was drafted to the complexity of the modern world. The sorts of things that constituents are concerned about week in and week out: access to transportation, the ability to have clean air and clean water, the ability to invent things and then be able to defend their inventions and their ideas against domestic and foreign assaults on them. In many ways, the large regulatory executive state of today, which I think would have surprised the founders, is, I think, the outgrowth of both the steadily increasing complexity of the modern era and the range of things that our constituents seek federal action to address. So, to give one closing example, I serve on the Financial Services Appropriations Subcommittee. I didn't have deep experience in the financial markets before coming to the Senate. The range of things that the SEC, the CFTC, and the CFPB are responsible for not just regulating, understanding, I think exceeds the capacity of the average senator, certainly this senator, to fully grasp. And so to suggest that we shouldn't have these regulatory agencies filled with experts and fully funded such that we can have an effective modern regulatory state in an incredibly fast-moving, constantly changing, but critical part of our economy, I think misses the steady evolution of the context in which we legislate or administer from the founding to today.
Fascinating. Senator Lee, you and Senator Coons may disagree about funding the regulatory state as a policy matter, but you have introduced a bill in March 2016 called the Separation of Powers Restoration Act. Tell us about that goal and what it's trying to achieve and how it fits into your view of whether the Senate is exercising its constitutional powers.
Okay, to put it very simply, that bill, which we just introduced a few weeks ago, is designed to undo a judicial overlay that was put on top of the Administrative Procedures Act called Chevron deference, so named for a case decided in the mid-1980s called Chevron versus Natural Resources Defense Council. What Chevron said was that an executive branch agency will be entitled to deference in court. The courts will defer to the agency's own interpretation of statutes that that agency is in charge of administering, of enforcing, and will also defer to the agency's interpretation of its own rules, its own regulations. The reason I introduced this bill is, first of all, there's nothing in statute that compels it. Secondly, it gives excessive power, power beyond even that which was intended to be conveyed at the time that the modern administrative regulatory state was created, to these executive branch agencies. Now, federal courts are specialists in this very task, in the task of interpreting statutory text and in interpreting text that is found in federal regulations. We ought to allow judges to use that training that they have to interpret that text, rather than to just defer blindly to executive branch agencies, which, notwithstanding their expertise and their training, aren't elected and they're not terribly accountable to the people. And so to me, it makes more sense to start paring some of that discretion down.
Fascinating. Senator Coons, this debate about how deferential judges should be to the regulatory state goes back to the progressive era. In the election of 1912, William Howard Taft said that courts should be very aggressive in policing overreach. And Theodore Roosevelt said courts should be so deferential that the people should be able to overturn judicial decisions. Do you agree with Senator Lee's goal in arguing for less deference to courts? And what do you think of the Separation of Powers Restoration Act?
I haven't had the opportunity yet to review Senator Lee's legislation or the blessing to really be better informed about exactly what it provides. But just taking your quick summary of it here, I'll just comment first. The federal judiciary is incredibly overburdened today due to a failure to move the confirmation of judges, even those who have come out of the Judiciary Committee unanimously. We have judicial emergencies in literally dozens of district courts right now. So we have an existing burden on the federal judiciary just dealing with their existing caseload that is a significant challenge to the delivery of justice in a timely way. Delays literally of years for dispositive motions that is driving litigation away from the courts and towards arbitration. So I'll just at the outset say, as a practical matter, to significantly increase the workload of the federal judiciary by empowering them to be the arbiters of the application by federal agencies of interpretive rules and to be more actively involved than they could be today in the determination of whether their statutory delegation was properly described and followed. We'll run into some very practical realities that right now our federal courts are truly struggling with the absence of filled judgeships, first. Second, Chevron strikes me as properly decided because in the absence of deference to an agency that is a specialist in a particular area, in the absence of a showing that they have exceeded their statutory mandate, you're frankly opening up to constant challenge some of the most important regulatory acts of some of the most important agencies. So I recognize the constitutional view that drives Senator Lee's initiative, but I frankly don't share it because I see, as I described before, whether it's the EPA in enforcing the Clean Air Act or it's the SEC in enforcing the regulatory acts around the registration of securities, we have agencies that struggle as it is to have the resources and the power and the ability to make rules and to take actions to enforce things that are clearly within their statutory mandate. To open that up to constant challenge through litigation, I think poses some significant challenges.
One more beat on this. Senator Lee, is this Congress fulfilling its constitutional responsibilities in overseeing these agencies?
The short answer to that question is no. Not just in the way that it's overseeing the federal agencies, but also in the fact that Congress is delegating in the first instance so much power to them that Congress, in many instances, isn't really legislating. I mean, if you added up all the instances in Dodd-Frank, for example, in which legislative power is delegated, if you added up all the instances in the Affordable Care Act in which legislative power, de facto lawmaking power is delegated, and I'm not, I won't limit it to just bills that are passed by Democratic Congresses with Democratic presidents signing them into law. Republicans have been just as bad on this. Republicans have participated and even fed this feeding frenzy of legislative delegation. This really is an issue that's neither Republican nor Democratic, it's neither liberal nor conservative. We're all, both parties have been active participants in this. But the problem we have is that when you have a regulatory rule that carries the force of generally applicable law, that is enforceable through the coercive force of the federal government, that needs to connect back up to someone who is elected. And with the executive branch agencies, that doesn't happen. Because these are good, hardworking men and women. They are highly specialized, they're well-trained, they're smart, they're patriotic, but they lack one thing that members of Congress have, which is the prerogative, the requirement that they stand for election every 2 years in the case of representatives or every 6 years in the case of senators. So getting back to your question, no, I don't think we're fulfilling our constitutional responsibility. It's not just in our oversight of them. And to the extent that we're allowing Chevron to perpetuate itself, I think we're also worsening the problem there Because no matter how important the regulatory or the statutory mandate in question is, it still doesn't constitutionally entitle an executive branch agency to deference. Now, I agree completely with Senator Coons with regard to the point that if someone comes into court with a deficient challenge to an agency's interpretation of a statute it's charged with administering, or with an agency's interpretation of its own rule, that ought not move forward. That ought not clog the arteries of the federal court system. But if they do come forward with something that's meritorious, something that's on the line as to which reasonable minds could disagree, I think that's an instance where the courts ought to decide it. They ought to decide it based on who is right.
One last beat on this, Senator Coons. We hope that these conversations will be a model for introducing constitutional arguments into the Senate itself. Have you heard constitutional debate about the constitutionality of the administrative state? Should there be? And what's your view about whether the administrative agencies are, in fact, constitutional?
Well, as you know, Jeff, a large part of why I was excited to participate in this with Senator Lee and with you this evening is one of the things that we really do not do in the modern Senate is debate each other, either directly or indirectly. Most of the conduct of the business of the Senate that I've heard described by my predecessor in this seat, Senator Biden, who was elected in 1972, he describes moments when literally the entire Senate would come to the floor to listen for an hour or two before a vote was cast, knowing that each party was going to put on the floor their strongest and most capable debaters on behalf of a particular point, and knowing that senators' votes could be swayed by a particularly compelling argument, whether over an obscure amendment or whether over a whole legislative scheme, a whole bill. We just don't do that today, partly because it's televised, and so we and our staff feel like we can know what's going on the floor remotely, partly because of changes in the media, partly because of cheap jet travel making us all rush home to our states and districts. Now, there's a lot of reasons, but we don't really engage in debate. I do think that debate around constitutional principles that is less personal and less partisan than much of the commentary we hear today would be a significant improvement for our Senate. The average American, and they're demonstrating this in the current election, believes that we're not listening to them and that we're not meeting their real needs. But I'm convinced the average American believes deeply in the Constitution and in the fundamental liberties that are pledged to Americans in the Bill of Rights and in the justice orientation of the work of this body properly understood. So it's my hope that we will have more pointed, more focused, more vigorous debate about constitutional principles to help tie back to the founding, things that sometimes get lost in current discussion. One of the most compelling discussions I've had with my 3 teenagers around how constitutional principles apply to them had to do with cell phones and the search of individual emails, and whether or not Section 2, I think it was 215 letters and the NSA bulk collection program was overreach or not, and what their expectation is of privacy. We had a conversation about what did the Fourth Amendment really mean? What were these sort of general writs of assistance? Why did folks in the colonial era feel aggrieved that British soldiers sort of barred into their homes? And what's the relationship between what's on your phone and whether or not your principal, your parents, or some government agency with a 3-letter name ought to be able to go through that without any sort of warrant or showing or restriction. That's something I think we generally have agreed on. But I actually think it is important for us to frame some of our current issues in the constitutional context so that all of us understand that the decisions we're making, whether intentional or unintentional, whether gradual or significant and well remarked in their scope, have constitutional consequences.
First of all, I'm inspired by your effort to elevate discourse in this way, and I think you both are doing it at this moment. And this issue of the constitutionality of NSA surveillance is one where you've both worked together. Senator Lee, you co-sponsored with Senator Leahy the USA Freedom Act, which Senator Coons supported. And I heard you at the Constitution Center tell an inspiring account of the battle against the writs of assistance that fired the American Revolution, including the significance of pamphlet North Britain 45. So I want you to tell that story and, sort of concisely explain why you think that there were constitutional problems with some of the NSA surveillance as it was initially formulated.
Okay, so there's this great story about John Wilkes. John Wilkes, the member of Parliament who served in the late 1700s during the reign of King George III. I tell this story in my book. It's called Our Lost Constitution. And now all 12 people who have read Our Lost Constitution have found it a life-changing experience.
It's actually great.
But for those of you who are not lucky enough to be one of those 12, I'll tell you the story. John Wilkes found himself at the receiving end of an overly intrusive administrative state in England. He started criticizing King George III in a series of weeklies called the North Briton. Number 45 of these weeklies was sufficiently critical of the king and his ministers that they decided to arrest John Wilkes. And they went to his house and they rummaged through all of his personal effects, all of his papers. Now, he believed that this was unlawful for a number of reasons, among them that the warrant that they used was a general warrant. It didn't say, you're hereby authorized to search the home of John Wilkes based on his involvement in offenses X, Y, and Z. It instead said, go out and find whoever had anything to do with the publication of the North Briton and get whatever you need out of them. There was no specificity requirement. It wasn't limited to John Wilkes or his home. If it was limited to his home, it didn't identify what part of his home or what papers or what they had to be pertaining to. Now, because North Briton number 45 was the publication that inspired all of this, the number 45, interestingly enough, became synonymous with the name of John Wilkes. And the name John Wilkes and the number 45 became synonymous with the cause of liberty on both sides of the Atlantic in the late 1700s. And it's part of what inspired what we now know as the Fourth Amendment to our Constitution. It's part of what inspired the particularity requirement in the Fourth Amendment that says that, police have to get a warrant if they want to search your house, subject to very limited circumstances. But they have to get a warrant, and that warrant has to state with particularity the things that are subject to the warrant. And as you were mentioning, Jeff, this is one area on which there is a fair amount of bipartisan agreement. Senator Coons and I both agreed, along with Senator Leahy and many others, that what the NSA was doing under Section 215 of the Patriot Act, through the NSA's collection of bulk telephone metadata, was wrong. What they were doing was analogous in many ways to the use of general warrants, because in collecting this telephone metadata, the information regarding who called you, when you talked, and for how long you spoke, collected and stored in a searchable database going 5 years back. This was all collected pursuant to a court order that basically said, dear Verizon, or dear AT&T, dear T-Mobile, send us all of your data. If that's not something akin to a general warrant, I don't know what is. Now, this is an area where I'm anxious to point out that Democrats were overwhelmingly in the same camp that I was. Republicans, at least at first, were less supportive. Democrats got it right on this one. I eventually succeeded in getting about half my conference, a little more than half of Senate Republicans to vote for the USA Freedom Act. The Democrats were there almost unanimously from the very beginning.
But there are Democrats who in these debates over the last few years have ended up siding more strongly with the security state and with the intelligence gathering community. So to give you credit where credit's due, you were leading early on, Senator Lee, in an area where there were very powerful voices, both Democrat and Republican, saying the post-9/11 environment is one where we frankly need to revisit what the Fourth Amendment means, and we need to surrender some of our concepts of privacy and liberty in order to be safe. That's a debate that is not over. That's a debate and a discussion that is only settled for the moment, and where developments in the last year in Brussels and in Paris and elsewhere, I think, suggest that we will revisit these conversations. I'm also struck at how the gathering of data by public and private entities and gathering and maintenance and searching of huge reams of data about each of us individually continues to accelerate, and I think will pose even greater challenges for us in the future.
When we think to the futures, Senator Lee, you've talked about how the mass collection of data can reveal so much about us, our intimate associations, our locations, our hopes and fears, that it calls to mind the general warrants. Think forward 10 years, a world where drones could fly in the air and track us 24/7. Would you make constitutional arguments against those sort of technologies, and what do we have to be most on guard against to protect the values of the Fourth Amendment?
Okay, so that presents some interesting questions. The first thing that we have to remember is for it to be a constitutional problem, for it to be a Fourth Amendment problem as opposed to merely a nuisance problem, we'd have to be talking about some type of government action. It is one thing for the 12 or 13-year-old boy next door to be flying his drone over your house. That is annoying, and it may even be engaging in some type of activity that's either tortious or criminal or both. But that doesn't itself present a Fourth Amendment problem. What presents the Fourth Amendment problem is that if government is doing that, then it's going to perhaps implicate the Fourth Amendment. Once we enter the realm of government action, we'd have to look at what the reasonable expectation of privacy is within our society. This is where it can get a little bit tricky, because drones, like telephones, didn't exist at the time that the Fourth Amendment was put in place in 1791. But we can nevertheless discern from the basic principles underlying the Fourth Amendment whether or not this would trigger Fourth Amendment problems. I suspect that if we end up having government surveillance drones flying over people's homes and looking into their backyards, looking possibly even into their homes, that's going to create a Fourth Amendment problem, because most of us would consider that to trigger what we would call our reasonable expectation of privacy. There was a case about 15 years ago in which the Supreme Court addressed whether or not police could use infrared technology to peer into a home and figure out what's going on in the home. It was really interesting what happened. In an opinion, I think authored by Justice Scalia, the court ruled that it was constitutionally problematic for them to do that. But then they added this, I don't know whether it was a footnote, they added a sort of side thought at the end saying, if at some point infrared technology becomes so ubiquitous that people don't have a reasonable expectation of privacy as it relates to freedom from surveillance from people using infrared goggles, then the court might have to revisit that.
Senator Kuhn, Senator Lee is absolutely right. He's described the Kylo opinion very well, and he points to a problem in the current Supreme Court doctrine. If the president were to go on TV tomorrow and say, Americans, we are going to fly drones, get used to it, that would lower our expectation of privacy, according to that logic, in ways that would lessen constitutional protection. And to get wonky, which I want to do here, the court has also said that when I turn over data to a third party, I lose all expectation of privacy in it. So some courts have held that when I walk down the street and surrender my geolocational information to Verizon or whatever, I've lost all expectation of privacy in it. Do we need an alternative to this so-called third-party doctrine, this expectation of privacy analysis? And if you don't mind telling us, what would that alternative be? What would the alternative be? What's the right constitutional way to address these problems of ubiquitous
This is a great question, and one that I think we can and should do a better job of stirring up the American people to talk to us as their representatives, as legislators about. I've been quite concerned about law enforcement's use of a device called a stingray or a dirt box that is successful in essentially making cell phones say where they are. When your phone is off, it still routinely pings the nearest cell phone tower simply to say, I'm here, and to register its presence and location, to get a check on time and so forth. Even when you're unaware that it's doing that, it's doing that. And this is a device that's now in fairly broad use by federal and local law enforcement that allows you to go over an area or through a region, either by airplane or by car, and essentially force all the cell phones in an area to respond to it. And so if you're searching for a particular phone number that you know is associated with a particular person to the particularity requirement, this is an understandable technique for finding a cell phone that you know is associated with a particular suspect or criminal actor, alleged criminal actor, and get their location. But it also allows the gathering, the collection, and the searching of huge quantities of data from people where you have no reason, there's no probable cause, there's no reason to gather that data. And it is, of course, hugely helpful to law enforcement in particular neighborhoods where there's high concentration of, for example, drug trafficking, to have logs that you can go back through that go over months and months or years and years of who was where at what time. I'll give you another example. There is a technology that's been deployed in Wilmington, Delaware, and is used in many other cities called ShotSpotter that acoustically figures out the exact location and time of shots. Well, there's nothing criminal about shooting a gun, except in particular residential areas at particular times of the day or night. There are local regulations about these things. And it allows the police to respond very quickly and to gather shell casings and so forth. But that's just one other example of ways that we are gathering, whether it's infrared signals. That case was actually about heat lamps being used to grow marijuana in someone's basement. So infrared signatures, sound signatures, cell phone records. I suspect we are on the verge of technologies that will allow third-party and government collection of just reams of data about us that we're not conscious have secondary consequences. A significant number of the senators with whom I serve seem to be wearing Fitbits these days. And
Nice. What'd you do today?
recording their steps, their heartbeat, how their sleeping patterns are going. iPhones now come preloaded with something that monitors literally everything about your health and your whereabouts. These are accessible, not just by third parties, not just for commercial benefit, but to law enforcement. And I think the test as you described it, that literally allows the government to push the boundaries of an expectation of privacy, shouldn't be the real test. I think we ought to be having a discussion about what boundaries of privacy protect what I view as a fundamental American right, which I will now suggest is the right to be weird. the right to have opinions that are unpopular, the right to follow a religion or a medical practice or a worldview that just doesn't quite fit with the majority of your neighbors. And one of the things I worry about most in this unbelievably interconnected social media age, as I watch my own teenagers, is that they are documented in ways that we never were. And I doubt many of the things I did in high school, which were goofy or offbeat or funny, I would have done if I'd known that all around me were cameras that could have captured me at any time. The average American in the average city is photographed without their knowledge at least 9 times a day, as they get in and out of elevators, as they get in and out of a metro station, as they get on and off a train. There are small cameras capturing us constantly. And with facial recognition technology, the scale and scope of the data that is being mined to determine our locations and to record and then allow the future searching of our life patterns, I think are a real and emerging threat to our privacy and our right to be weird.
I love the phrase, the right to be weird, and so would my hero, Justice Brandeis, who talked about the right to be let alone. I think we have some homework for both of you, actually, which is to come up with an alternative to the third-party doctrine that will protect privacy in an age of new technologies. We're going to have some off-the-record constitutional briefings with the Aspen Institute and the help of the Rodell Foundation, so we can ask them to help us. But Senator Lee, do you mind thinking aloud for a beat on what alternatives to the third-party doctrine might be?
Sure. First of all, we have to think through the fact that although AT&T or Verizon or some other telephone carrier might have all kinds of information about you, AT&T or Verizon or T-Mobile doesn't have the power to arrest you, doesn't have the power to impose a massive tax penalty on you the same way that a government does. And so there is a critical difference between having a third-party carrier, a third-party service provider, a private party having those things, and government having them. And so the whole reason why this comes into play, and the reason why you're asking the question, is because when there is a short hop between that and the government, that's where the problem comes into play. Because if there is an understanding, or if the government is able to proceed under the theory that, well, you didn't give this to us, you gave it to a third party, and the third party's choosing to hand it over to us because AT&T or Verizon or T-Mobile might not care that much about whatever amount of privacy you're going to lose if they hand that over. They might, on the other hand, care about being ridiculed and denigrated as unpatriotic if they don't want to hand it all over. And so that's one of the reasons why they might be inclined to hand it over. So I think we have to be constantly looking for those short hops between information that has a significant bearing on our privacy, that if put in the hands of the government could be abused. We've got to look for those little short circuits and try to figure out a way to stop those short circuits from happening and thereby derailing our privacy. I actually think the USA Freedom Act can be a good model for this, because this is exactly what we faced with the USA Freedom Act. They were using the third-party justification there because they were saying, well, look, we're just asking the telephone provider to give us information they already have. It's not necessarily their privacy that they're concerned about. These are just business records. But we had this problem. And so what we did there was we created a special system whereby if the government wanted to get an order pertaining to a particular phone and wanted to be able to search who had called that phone and who had been called by that phone 2 steps out, they could put out a request to the telephone service providers and they could get a response back within a very limited period of time. This allowed the government to have access to the things it needs to have access to, but it would limit the government's access to those things to the government's own need to know. See, what we're worried most about is the government gaining a big database like what they had before under Section 215 of the Patriot Act, where at any time it could be searched. Now, there were policies in place at the time, policies that I'm willing to assume for purposes of this discussion were being followed, that prohibited them from accessing this database except in these very specific circumstances. But what we worry about with the Fourth Amendment is the possibility, and indeed the near certainty, that they eventually will be abused. So one of the things that I talked about in my book on this point was that there was this great chapter in the history of the United States Senate in which Senator Frank Church from Idaho conducted this series of hearings about government abuses of wiretaps and related activities. He pointed out that in every presidential administration, from FDR up through Nixon, the administration in question had used the country's, the United States' intelligence gathering apparatus to engage in political espionage. So this was not just something that happened under a Democrat or under a Republican here or there. It happened over and over and over again, under every Republican and every Democrat for a significant portion of our history. We know this sort of thing happens. We know this sort of thing will happen again because it's, unfortunately, one of the things that human beings do. They behave badly when they have access to a whole lot of information that they can manipulate. So we've got to always be looking for that short hop that occurs between third-party data and government access to that third-party data and just prevent the government from having free, unfettered access to it.
I love both of your passion and intelligence on this question. I think we can do a huge amount of good for the country in thinking hard about a new constitutional doctrine that will translate the values you both talked about into the 21st century. One quick beat on the constitutional question that's being debated in the Senate right now, in the spirit of both of your thought that constitutional debate is good. We've had this bipartisan agreement. You both disagree about whether the Senate has a constitutional duty to hold Supreme Court hearings on the pending Garland nomination as concisely and constitutionally as possible, leaving aside all the policy arguments. Senator Coons, why do you believe that the Senate has a constitutional duty to hold hearings?
Well, separation of powers only works when each branch actually conducts its business, when it carries out its constitutional responsibility. The president was required to nominate a replacement for Justice Scalia upon his untimely passing. And advice and consent, which is our Article 2, Section 2 requirement in that situation to provide advice and consent, cannot mean to refuse to even meet with the nominee, to hold a hearing on the nominee, to have a vote on the nominee. And my concern is that by saying that constitutes advice and consent, that's doing our job, is to say, for this president, no, we will not do any of these things, pushes further down the question of, are we required to actually carry out our obligations? Separation of powers works fine when each branch in turn takes its place and its part. When the Voting Rights Act, for example, takes a very tough blow from the Supreme Court, the Congress has to be able and willing to pick up and address the challenges presented to it. And you can't simply ignore the fact that the Congress has recently acted unanimously in order to reaffirm the Voting Rights Act, for example. I'm taking us off into Shelby County. Forgive me, you asked us to stick to Merrick Garland. I wrestle with the current inaction, the unwillingness to carry out our responsibilities to confirm district court judges, to confirm circuit court judges, and now to even consider meeting with a nominee. This cannot mean what advice and consent is under the Constitution.
Senator Lee, tell us why you believe that the Senate does not have a constitutional duty to hold hearings.
First of all, when you look at the plain text of Article 2, Section 2, you will discover that it is devoid of any shall language with respect to the Senate. It does say that the president may nominate, and with the advice and consent of the Senate, may appoint officers, government officials, judges, and so forth, as permitted by law. But it doesn't contain any shall language. It just says if the president does nominate and if the Senate does confirm, then the person can take the office. There are other provisions in the Constitution where shall language is used. In the take care clause, for example, there are some shall obligations that go along with the presidency. This is not one of those circumstances. It's interesting that there were, during the Constitutional Convention, a number of other options proposed and considered. Throughout most of the duration of the Constitutional Convention of 1787 in Philadelphia, the one that was on the table was one that was authored by James Madison. There were other times when other proposals were considered, including some that would have given the appointment power to Congress generally, others that would have given it to the Senate in particular. Madison's proposal was to give the power of appointment to the president, but to give the Senate an affirmative veto right, such that if the Senate chose to veto, then they could stop it. Otherwise, the president's nominee would become the appointee. That one was not selected. Instead, the one that was selected was one that came from Massachusetts, based on the Constitution of Massachusetts from 1783. And it was a shared appointment power. This one that says, okay, the president nominates, and if the Senate chooses to confirm, that is, if the Senate chooses to give its advice and consent, then the nominee becomes the appointee. Madison, years later, in a letter, described this power and described the relationship that is set up between the presidency on the one hand and the Senate on the other as directly analogous for all intents and purposes to the relationship between the House and the Senate. Meaning, when the House of Representatives passes legislation, as it routinely does, there is no affirmative shall obligation on the part of the Senate for us to pass that legislation, nor is there any affirmative shall obligation for us to even consider that legislation. In fact, I believe in the last Congress, there were at least 300 or 400 bills that were passed by the House of Representatives that were never even taken up in the Senate, never given an opportunity for an up or down vote. This is the same kind of thing. Now, we can have a different discussion about politically, or as a matter of policy, whether it's a wise thing to do what we as Republicans are doing. But that is a separate question. It is my strong belief that this is not a constitutional question because there is no affirmative constitutional obligation on the part of the Senate to act. The policy question and the political question must be separated from the constitutional question.
Beautiful. Regardless of how you come out on that question, you can't help but be struck by the intelligence and precision of those constitutional arguments, and I'm grateful to both of you for beginning to engage them. We need to end soon. I think I want to end by asking each of you, because you've joined a project of constitutional education for America, and that's what the Constitution Center's mission from Congress is. Senator Coons, what is the clause or part of the Constitution that you think Americans don't know enough about, and what do you want them to know about it?
The one they don't know enough about has to be the Third Amendment, but that's
None of us know a lot about that.
Spent a lot of time worrying wrong about that one.
Absolutely. And they can find out as you think about your favorite clause. A quick plug alert on the Interactive Constitution, this thrilling online tool we've just launched, co-sponsored by the Federalist Society and the American Constitution Society, where the leading liberal and conservative scholars in America are writing about every clause of the Constitution, describing what they agree about and what they disagree about. It's an amazing tool, constitutioncenter.org. Check it out. The Third Amendment was uncontested, so both FedSoc and ACS agreed that Gordon Wood could write about that for both of them because there wasn't enough
I'm
disagreement.
probably wrong, but if I'm not mistaken, the Delaware Constitution actually, the Delaware Bill of Rights actually influenced in some ways the choice of language and the choice to include an amendment about the quartering of troops in peacetime.
We can find out about that on the Interactive Constitution by clicking on the Third Amendment. There's another part. You'll see the Revolutionary Era state constitutions. We'll do this after the show, and you can compare the text of the Delaware Third Amendment with the U.S. and find out how much percentage of overlap.
I will say, I think Senator Lee and I have a further conversation to have about separation of powers, the confirmation of a justice to the Supreme Court, U.S. v. Nixon, and whether or not his analogy, a good one, that the House and Senate send back hundreds of bills, and frankly, no harm, no foul. There is no shall, there is no constitutional mandate that we take up their bills or they take up our bills. But at what point does a refusal to engage or respond become so egregious to the functioning of the other branches that it raises the question that we're literally impeding the constitutional scheme? Can we claim a prerogative to understand advice and consent in a particular way that defeats the functioning of the judicial branch? I think that's worth discussing. I agree that there are political and policy concerns here, but for the long term, I worry deeply that the Senate continues to simply grind downwards in terms of its exercise of the confirmation power. Regardless of party, we seem to steadily head downwards in terms of our engagement, our purposefulness, and the positive productivity that we should be contributing towards constitutional deliberation in the course of confirmation hearings.
We will have that further conversation. We'll reconvene in a few months. But I do. Can you identify a constitutional provision that you sort of want people to know more about?
Obviously, Article 2, Section 2.
Just for that very reason. Okay, well done. Excellent.
A constitutional provision that I think doesn't get enough attention.
Yes.
Well, obviously the
It's the
Commerce
Commerce
Clause. I mean, enough said there. But
Goes without saying, duh.
one could make that argument. I wasn't going to use that one, but one could make that argument for this reason. I was going to mention the 10th Amendment. The 10th Amendment is something that comes up from time to time, and that's the amendment, of course, that says that powers not given to Congress are reserved to the states, respectively, or to the people. I love that last line that's set up by the comma at the end, or to the people. When you reserve power to the states, it's not just that you're reserving it to some abstract political construct known as the state. You are reserving it to the people because the power that is exercised at the state and local level is more accessible to the people. It's more compliant to their will. And this is one of those issues that I love because it is, by its very nature, not necessarily either Republican or Democratic, not necessarily either liberal or conservative. In fact, one of my favorite things to do is to come up with hypothetical scenarios in which a politically progressive policy interest could actually be enhanced and furthered by a return to federalism, by a restoration of the 10th Amendment. Now, Chief Justice Stone was correct when he pointed out that the 10th Amendment really is but a truism. Remember when I first read that line, I was disturbed by it. I thought, oh, he's trying to denigrate it. But the more I thought about it, the more I realized he was right. These are two sides of the same coin. It is necessarily true that the 10th Amendment means only as much as the powers of Congress, and therefore the powers of the federal government, are limited. In other words, if the powers of the federal government are unlimited, the 10th Amendment means exactly nothing. Now, what this means is that insofar as our non-spending clause power goes, our regulatory power, most of that, the bulk of it, comes from the Commerce Clause. And that's how this really does tie into the Commerce Clause, now that you mention it. Since April 12, 1937, when the Supreme Court decided a case called NLRB versus Jones and Laughlin Steel, we have had a virtually limitless Commerce Clause. There's almost nothing Congress can't regulate under the Commerce Clause, nearly every aspect of human existence. On only 3 occasions since April 12, 1937, has the Supreme Court identified anything that's outside Congress's power to regulate under the Commerce Clause. Once was in United States versus Lopez, where in 1995, the Supreme Court invalidated provisions of the Gun-Free School Zones Act, saying that the mere bare intrastate non-commercial possession of a firearm in the presence of a school zone is not itself the type of thing that can be regulated by Congress under the Commerce Clause. In 2000, in a case called the United States versus Morrison, the Supreme Court concluded that certain acts of violence, assault, battery, so forth, are themselves, when they occur intrastate, not necessarily covered by the Commerce Clause. And then again in NFIB versus Sebelius in 2012, there's an asterisk next to that one, but Congress found that the Supreme Court found that Congress lacks the power to tell people they must buy health insurance under the Commerce Clause. But that one doesn't really count because the court went on to say that that is a legitimate power of Congress's power to collect taxes. I strongly disagree with that conclusion, but that's a discussion for another day. My point here is simple. In addition to, it's my belief, I tend to agree with something Justice Scalia used to say, which is that the Bill of Rights and every other protection in our Constitution, very, very important. And every other protection in the Constitution will come to a point where it means exactly nothing without the structural protections of the Constitution. And the structural protections are twofold. The one is the horizontal protection called separation of powers, which we discussed earlier. The other is the vertical protection, which we call federalism, which is what's protected by the 10th Amendment. But the 10th Amendment means nothing if the powers of Congress are unlimited, and so that's where I would turn our attention next, is back to federalism and to the principles embodied in the 10th Amendment.
Well, we have a topic then for our next conversation. Ladies and gentlemen, I have to say that in these polarized times, when it is fashionable to talk about how politics is broken, I am inspired by seeing the intelligence and the passion of these two senators and the fact that they agree about some issues and disagree about others, but they are united by their love for the greatest document of human freedom ever written, and that is the U.S. Constitution. I'm thrilled by the launch of this program. I can't wait for our next conversation. Ladies and gentlemen, please join me in thanking our visiting scholars, Senators Coons and Lee. And now please enjoy some constitutional refreshments, and we will continue the conversation. Thank you so much.